Hello again, this is Troy Moore from the Law Office of Troy Moore in Houston, Texas. A lot of people wonder about what is a will generally. And a will, in its most basic form, just represents who gets your property after you pass away. So it is a written document that is legally enforceable that spells out who gets what from your estate when you're gone and in what percentages that you set out within the will. So in its most basic form, wills are generally written by somebody else. A lot of times they are typed up. If the will is typed up, it has to be signed by 2 additional witnesses in addition to the testator. The testator is just the legal word for the person who is making a will. So the document has to be signed by the person that is making the will, and it also, in Texas, has to be witnessed by 2 credible witnesses that are at least 14 years of age. Now, as far as the will maker goes, or as it's legally called, the testator making the will, that person has to be at least 18 years of age and be of sound mind. This is also called having testamentary capacity. So the part about testamentary capacity means that they just essentially need to understand what document they are making. It's been said that testamentary capacity is just short of the capacity to contract, so it is just a general understanding of what you are doing that's required in order to make a will valid. So what is the purpose of a will? The purpose of a will is to define who gets your property after you're gone so that there is no, hopefully, dispute over who gets what from your estate. So the document itself is legally binding and will be enforced by the courts. In order to carry out the terms of the will generally needs to be probated in probate court. A will is not self-enacting. It is a special type of lawsuit called a probate administration that is filed on behalf of usually the executor or one of the beneficiaries to the will to have the estate probated. The court then appoints the executor that is named in the will. The executor's job is to implement the terms of the will and to transfer the property to the people that are designated in the will. So after the court appoints the executor generally in an independent administration goes out and takes care of the things that they need to take care of, such as accessing and transferring money from bank accounts, listing real estate for sale, collecting on any debts that are owed to the decedent in that case, and doing any other thing legally that are financial loose ends that need to be taken care of. What does a will not do? Well, a will does not designate who can make medical decisions or financial decisions for you while you are alive. A will only takes effect once someone has died, and a will does not designate who can make financial decisions for you if you're alive but you're incapacitated. And same thing goes for medical decisions. So in those situations, you want to have a financial power of attorney, which is legally called a statutory durable power of attorney. That document sets out who can make financial decisions on your behalf should you be alive but unable to make those decisions. And the medical power of attorney designates who can make medical decisions for you if you're alive but you're unable to do so. The legal requirements for a will, I touched on briefly earlier. If it is typed up, it needs to be witnessed by two other people who are there watching the will maker actually sign the will. And in addition, it can also be made as a, quote, self-proving will. And in probate court, a self-proving will is much easier to get into evidence for the whole probate case, and it streamlines the whole process of the court hearing. Now, you've probably heard of a holographic will. Those wills are made and they are valid, but those wills have to be made wholly in the handwriting of the testator, meaning the will maker, and that person also has to be at least 18 years of age and of sound mind. So holographic wills can be written on a cocktail napkin, they can be written on a piece of hotel stationery, a post-it note, really anything. There is also an old case from a farmer that got stuck in some farm equipment out in the field and wrote his holographic will on the side of his tractor, leaving everything to his wife by scratching it into the side of a tractor. Pretty amazing. So there is a lot of confusion by people in the public about what a will is versus a living will. And you might be wondering, what is a living will? Well, a living will is a common term for a directive to physicians. A directive to physicians designates ahead of time what kind of medical care you want or don't want in the event you are alive, but you're unable to communicate with your physician because you are incapacitated and you've been diagnosed with a terminal condition or an irreversible condition. So a living will designates, do you want medical care in that case or do not want medical care in that case? A living will is more of an end of days document. The majority of the time when somebody makes a living will, it's to specifically say that they don't want any more medical treatment if they are unable to communicate with their physician and they've been diagnosed with an irreversible or terminal condition. So I hope that helps with any questions that you have. If you have any other questions, please feel free to call my Houston area office, 281-970-8039, and we would be happy to help with any estate planning questions you have regarding wills.